Your Honor, you spoke so highly of Mr. Hoffman the other day that I invited him back.
Good afternoon, Mr. Hoffman.
Good afternoon. Good to see you again, Your Honor. Your Honor, Nicholas Hoffman for UNFW, and I have some brief PowerPoint slides that I would like to use. So I think that Mr. Kemp slightly misrepresented the substance of Dr. Revchuk's opinions here, and is trying to force him into essentially this round hole, a square peg of medical causation and having to come up with a specific pathogen. So that's really a little bit different than what Dr. Revchuk's going to testify about at trial. So before I get to specifically what Dr. Revchuk's going to testify about, obviously Your Honor knows this well by this point, but it's worth stating for the purposes of this motion because it's important for the analysis of the Williams case and the cases that come after it. What are plaintiffs' theories, and what are plaintiffs' experts going to say? So plaintiffs here, obviously, as Your Honor knows now, intend to try to present expert testimony claiming that all plaintiffs were injured by a widespread toxin, they say that's hydrazine, that was in all real water product, both home delivery and retail bottles, due to manufacturing issues with the real water concentrate. You've heard significant argument from Mr. Kemp and his colleagues on that point. The individuals who you've also now heard their names who will provide that sort of testimony are plaintiffs' experts, Dr. William Michael Freeman. This is our favorite guy with the med.dr. I'm still anxiously waiting to hear what Your Honor thinks about the Royal Pathology Fellowship. But that's another individual who's going to testify about the bad batch theory. And then Isam Najm, I think is how it's pronounced. He's going to testify about how hydrazine is specifically created. And then Catherine Hutt. So those are the individuals. These are who plaintiffs are going to put up to try to present to the jury that there was this widespread toxin, hydrazine, and that essentially it all came down to this specific manufacturing issue with the real water concentrate. Now, what Dr. Revchuk is going to be able to do is he's going to be able to show that plaintiffs cannot satisfy their burden to prove causation. So Dr. Revchuk is a preeminent engineering expert and water treatment systems expert. He has a degree in environmental science and engineering from UCLA. He has a master's from UCLA. He's a professional engineer in both California and Nevada. He does this for a living. He specifically looks at engineering failure analyses of water systems, and he performs those. He does that both in litigation and outside of litigation. He is a board-certified environmental scientist, and as I said, he specializes in assessing water production systems in relation to things such as, and I know this is a term that you've heard quite a bit about, hazard analysis critical control points, or HACCP, HACCP, good manufacturing practices, and root cause analyses of failures in water production systems. Those are just examples. So that's what he does for a living. Obviously, Dr. Revchuk did significant work in this case. I know Your Honor has his reports. I think that we might have only actually submitted his report and not the actual tables and appendices with it, but I see that from the report alone, Your Honor should have 62 pages of his analysis and explanation of what he did in this case. Just to run through it briefly, he performed multiple inspections of real water facilities. He inspected the Henderson facility, the one that you've heard a lot about, on multiple occasions. He inspected the Mesa, Arizona real water facility. He analyzed how it was set up, and he looked at, for both of those, the water production equipment, and he documented it all with extensive photographs. He's going to explain real water's water production process to the jury and how it was set up, the HACCP analysis, and whatnot. He personally inspected the titanium tubes that plaintiffs claim created the hydrazine, and then he also personally inspected multiple UNFW facilities. So he inspected the facility that the water allegedly would have come from for both Keith Haley and for Richard Belsky. Those are in Rockland and Moreno Valley. And then he documented UNFW's process, how it handles the retail bottles of water with photographs, and he's going to explain that to the jury. So, based off that, is completely untrue that all that he's going to try to do is get up there and talk about some unknown pathogen or whatnot. He's going to talk about exactly what he does for a living, which is, he goes in, he assesses a water treatment system, he looks at how it's set up, he documents it, he talks about failures with it, and he talks about things such as HACCP, critical control points that are lacking and whatnot. Obviously, based off of his experience, Dr. Rebchuk easily satisfies the NRS 50.275 standard for special knowledge, skill, experience, training, and education, and I did not even hear Mr. Kemp dispute that, so I'll move on from that. But I think it is important to note that Dr. Rebchuk's testimony will also be of assistance to the jury. So, under NRS 50.275, this is number 2, his specialized knowledge is going to assist the trier of fact to understand the evidence and to determine a fact and issue. And, Your Honor has heard significant testimony about things like HACCP, water production, all of these various terms that I just used. Well, Dr. Rebchuk's the actual guy who went in and analyzed it, and he has photographs that he's going to get up on the jury stand, and he's going to go through them and explain them to the jury. He's going to explain the HACCP and what he saw and where various things were lacking, if there were haphazard plumbing, and those types of things. So, Your Honor, what he's also going to do is he's going to explain how he considered plaintiff's theory regarding this supposed widespread toxin, and I'll show some testimony here in a few moments. And he's going to consider their theory about it having been produced by manufacturing failures specific to the real water concentrate. And then he accepted and he considered the plausibility of plaintiff's theory, and he's going to contradict plaintiff's theory at trial by explaining why it is not the most probable theory following his engineering failure analysis.
How can he do that?
And I'm going to get to that, Your Honor. So
I want to know, because he's not a medical doctor. Right?
You're right. He's not a medical doctor.
He's an engineer. He has a PE. He has a PhD. I get that, and he's probably really smart.
You're correct on all those accounts, Your Honor. So he is not a medical doctor. He does not purport to be able to provide medical causation testimony.
But isn't that what he's doing?
He is not. He is not. So Mr. Kemp has...
But the reason why I say that, though, is this. I mean, number one, how can he say there's an unknown pathogen? Right? He's not a medical doctor, right?
Yeah.
And in order to offer up some unknown pathogen, I would think we would have to know and identify specifically with some form of particularity what that pathogen is.
And so, Your Honor, the unknown pathogen language that you've latched onto, that's from Mr. Kemp. So that's not part of Dr. Rebchuk's opinions. Dr. Rebchuk's opinions are well detailed in his 62-page report that I know Your Honor has in the exhibits. And he goes through, and his testimony, Mr. Kemp, he showed you one small little section that talks about the UV and the ozone, for instance. Well, if you even open up the table of contents for Dr. Rebchuk's expert report, you'll see he goes through systematically through HACCP SOPs, he goes through the SOP requirements, he goes through what Real Water was doing versus what they were not doing, he goes through the 5-gallon jug process, he goes through the Mesa, Arizona process. I could go on, missing filler isolation valve that he found, the haphazard plumbing, the dose flow and lowing machine. He goes on, and I'm just reading from his table of contents, which goes on for 3 or 4 pages about the very systematic failures that he found.
Yeah, no question about that.
And Your Honor, I know that you've admitted other testimony and evidence relating to those exact failures, so we certainly believe that we're entitled to have an expert opine about those. Now, I'm going to get to what I'm saying about him not giving medical causation testimony, because I know that that's what Your Honor is very interested in. But just to be clear, we believe that just because plaintiffs are trying to claim that he can't identify a specific causative toxic agent, more probably not, that does not exclude him under the case law of Williams, for instance, which is what plaintiffs referred the court to. As Mr. Kemp conceded, none of the health agencies, FDA, CDC, Southern Nevada Health District, have been able to identify the specific causative agent. And I heard Mr. Pepperman when I was last here, I think this was last week, maybe the week before, he said, for instance, that even if plaintiffs had not identified the specific toxic agent, that they would still be able to prove causation. And in fact, I think that's true. I think that even if plaintiffs could not have found hydrazine, they could try to put together some sort of argument of causation. where they thought that it was, and I think the Wilson v. Circus, I know that the court, has heard that case before.
Here's my question for you, because
Sure.
I did review his report.
Yeah.
And I'm looking at page 1,
Yep.
index 153. And that's his assignment and retention. And Alex Revchek, and I guess it gives his credentials, which are pretty impressive: B, EE, NB, PE, BCES of Exponent Inc., was retained by McGuire Woods LP on behalf of United Natural Foods Incorporated, UNFI, as a wholesale distributor of retail-sized bottled real water to conduct an engineering root cause evaluation into the probable causes of liver injuries outbreak associated with real water alkaline water product, period, close quote. So how can he give a root cause analysis as to the probable cause of liver injuries in this outbreak? Because that's what he was retained for, right? At the end of the day, we can talk about all the things wonderful things he did do regarding potential systematic failures at real water. But how can he give probable causes of liver injury outbreak associated with real water alkaline water products? Close quote.
Yeah, and Your Honor, you point to what has been listed there. I think that obviously isn't a full picture of everything that he did that's explained elsewhere in his report, and that also was explained at his deposition. I mean, at his deposition, he made very clear that he did assess the plaintiff's experts and take them into consideration, assess the plausibility of them, and that he was specifically rebutting them. And if I could put on the screen just briefly, John, this is page 46 of Dr. Repchuk's testimony. This is Exhibit A to our opposition, page 46. You'll see, I think, a better picture of the type of analysis that he did. So he really is going to address at trial the theories put out by plaintiff's experts. So, plaintiffs, for instance, have Dr. Najm, Najm. Dr. Najm, similarly, cannot provide any sort of medical causation testimony. He's not a doctor as far as I'm aware. He's going to testify, as far as I can tell, and plaintiffs can correct me if I'm wrong, but he's going to testify about a very specific issue and how hydrazine could potentially be created. He has theoretical pathways, quote unquote, and how it could have been created in the manufacturing, as one example. So, plaintiff's own expert.
I don't think necessarily. I mean, I don't remember what his credentials are.
Yeah.
But a chemist, engineer, et cetera, potentially could do that.
Yes, and so that's my point. So,
but what about causes of liver injury outbreak associated with real water alkaline water product? That's kind of tough for an engineer to do.
Yes, and I don't think that he's actually purporting to, give any sort of medical causation testimony. I can assure you that that's not what he'd be offered for a trial. What he'd be offered for a trial is specifically addressing these issues, that are brought up by plaintiff's theory, going through his root cause analysis and explaining what is the most probable, what issues there are that show that what plaintiffs have presented are not the most probable. So, John, on page 46 of Dr. Repchuk's transcript, here we have one example starting at line 20.
Yes, sir. Starts at 154.
Page 46, line 20. This is for the internal numbering system. So this would be page, on the top right, you see 154 there. This would be page 46 of that.
Yeah, the exhibit I, it starts at 154. Goes from 7 to 154.
Okay, this must be in plaintiffs. Well, I can come back to that. It must be attached to theirs. But essentially, Dr. Repchuk was asked specifically about, I have it here in front of me. So I think this is a good example. This is page 46 of his transcript, line 20. And Mr. Kemp asks him, he says, question, okay, would you agree that it's more likely that the hydrazine was created in the concentrate before it got to the Henderson facility? Okay, his answer, I reviewed Dr. Najim's pathways and they are theoretical. He acknowledges that he was not able to do any measurements of his own. He acknowledges the black box of the titanium tubes themselves and this kind of configuration that may have an insight with the materials therein. So I would love to see more information about his theories, but the application of Dr. Najim's theory that hydrazine that was generated in concentrate manufacturing process was responsible for all potential, responsible for the outbreak, that's inconsistent with the overall distribution of the product that Real Water has sold. And then Mr. Kemp cut him off and started saying something, but then he continued testifying and said, there are several ways to produce hydrazine. I'm aware of Dr. Najim's reports where he proposes 2 theoretical pathways, but I also want to point out that certain algae are capable of producing hydrazine, or a mixture of some basic chemicals like ammonia and chlorine can yield some hydrazine. And he goes on and he talks about, Dr. Najim's hypothetical pathways and whatnot. And, this is the type of testimony that he would give at trial, which is, assessing plaintiff's theory and explaining why plaintiff's theories specifically are not the most plausible or most probable theory. He would specifically contradict and rebut plaintiff's causation theory, which is that there's a widespread toxin, hydrazine, that was basically affecting all of the water, including retail bottles and the home delivery bottles. He would explain that based off of his own root cause analysis, including all the evidence he looked at, his inspections of the facilities and whatnot, that is simply not the most probable. So, John, if I go back to the PowerPoint, obviously that brings us to Williams. And I know the court knows the Williams case well. That's 127, Nevada 518. I'll just go over it very briefly. So, I've pulled a couple excerpts. I think that it's very important to distinguish in the Williams case between the 2 different experts that were at issue. So we had the Nurse Hambrick, who we've discussed in connection with prior motions limine. Actually, in fact, in connection with Dr. Freeman. And then in that case, there was also Dr. Jonathan Cohen, who was a professor of medicine. Plaintiffs' motion and reply are focused on, as far as I can tell, Nurse Hambrick. I don't think Nurse Hambrick really has any sort of relevance to this motion about Dr. Rebchuk at all. I think that the expert who is important here is Dr. Cohen.
I think one of the important components of Nurse Hambrick, and remember this, Nurse Hambrick was peer-reviewed, had taught, and was apparently somewhat respected in the area of aseptic practices in the scope room. And that's why the defense offered her up. And she admitted in her deposition examination that she didn't diagnose. And that was the realm of the doctor, something to that effect. That's what I remember from trial. And ultimately, I made a determination that she didn't meet the qualifications requirement as far as that specific case is concerned. And so my question would be in this respect, because when it comes to medical causation, I realize you have Williams, but then before Williams you have Morsicato, and before Morsicato you have FGA versus Giglio. And it just so happens out of the 4 cases, I was a trial judge in 2. and my point is this, and like in Morsicato, there's a section in Morsicato that deals specifically with the exercising of medical judgments. And that's what the Supreme Court focused on in Morsicato, right? And so I look at it, and there's no question, this gentleman, he appears to be impeccably qualified for certain areas. There's no question about that. But when it comes to issues regarding medical causation, independent alternative causation, and the like, if he can't diagnose, if he doesn't exercise medical judgment, how could he ever opine on medical causation in this case? And just as important, too, I understand there's this discussion regarding root cause analysis, but that's not the standard in the state of Nevada. It's to a reasonable degree of medical probability, right? That's the standard when it comes to medical injuries. And he might be great and he probably is, in the area of the production methods of real water and all those things. I'm not saying and maybe what safety measures should have been in place and all those things. But once he goes beyond that and starts talking about pathogens, toxins, agents, contaminants, and things like that there's been no evidence of, right? And even if there was, as far as the medical causation, if there's a contaminant or pathogen, he wouldn't be the person to tie it up anyway, because he just doesn't have the medical background to do so. Now, as far as the facility and potential problems, oh yeah, I agree. Potentially, there might be areas where he can opine in that area.
Yes, and I appreciate that, Your Honor. So to be clear, and I feel like I've tried to emphasize this, but I want to emphasize it again. So Dr. Rebchuk is not going to try to opine on medical causation. He's opining on engineering failures allowing an outbreak, not the medical cause of liver injuries themselves. And I'll go through this, and I actually traced, I know Your Honor enjoyed this when we did the substantial similarity. I looked at every case that the Supreme Court of Nevada had after this Williams case, citing it and whatnot. And so, I'll show you that. There's a 2018 case that I think is pretty similar to this issue. But, because Dr. Rebchuk is rebutting and contradicting plaintiff's theory of causation,
but he can't do that.
He is allowed to rebut various portions of their theories. So, for instance, Dr. Najm, I think he's a doctor. Dr. Najm is giving a theoretical pathway of hydrazine. That's one example. Now, obviously, Dr.
Yeah, I look at
Rebchuk.
it. I'll be clear. Maybe and I haven't really heard this yet. We'll talk about it. Maybe whether hydrogen could have been created at the plant or something like that. That's one thing. But to sit and opine as to medical causation vis-a-vis liver failure, that's another issue, right? And the reason why I bring that up, I think Nevada law is pretty clear when it comes to medical causation issues, right? And even to offer up alternative causation theory or plausibility causation theory.
Yeah, and he is not purporting to tie it up and give the overall opinion of, he is not trying to carry all that water that Mr. Kemp wants him to carry. So he is not attempting to, say that he's giving this overall opinion that there's a specific pathogen that, this is what caused X plaintiff's injury. So what he has done is, as I said, an engineering failure analysis. This is exactly what was allowed and affirmed in the Williams case. So this is exactly along the lines of Jonathan Cohen, the professor of medicine, who was unable to say what the specific vector was in this laboratory. It seems familiar to me because I see here on this quote I have up that the plaintiff's counsel, I think Mr. Kemp was involved, had labeled this theory the dirty scopes theory, as he has various names for Dr. Rebchuk's theory here. But in any event, here Dr. Cohen was unable to identify the specific piece of equipment that had transmitted the virus in that case. The Williams court explained, as Your Honor I know is very familiar with, that once the plaintiff has demonstrated a prima facie case and met his or her burden, the defendant can traverse the plaintiff's case in three ways.
Now go back to the far side.
Sure.
Here's the difference. You look at Jonathan Cohen, right?
Yep.
MD, professor of medicine, right? He meets the qualifications requirement that was discussed in Williams, right? You have qualifications, assistance, and limited in scope. So my question is this. Potentially, he can offer up plausibility or independent alternative, but how can your guy do it? Because he's not a MD, professor of medicine. He doesn't exercise medical judgment, right? That's the touch. That's what happened. In fact, we had, I think in Morsicato, but I haven't read that case in a long time, but in Morsicato, the problem was, I think it was Mr. Kemp's partner's expert, right? He couldn't opine to a reasonable degree of medical probability. That's my recollection. Okay, I knew somebody couldn't, but, and Judge Earl let it in anyway, right?
Yeah, he had a list of potential things.
Yeah.
Potential cause of agency and profit.
Yeah.
Allegedly,
I understand.
caused some injury. So he gave the list, and then Judge Earl kind of let him.
Right, I know, and it's funny how all these cases are connected in a way, because I worked for Judge Earl for years, and he was the trial judge in Morshicato, right?
Yes. So, Your Honor, I just want to be clear again. So, Dr. Rubchuk, I shouldn't be saying doctor because I think it's giving you a misconception that we're trying to.
No, it's not. No, okay. I respect. No, he's
a PhD.
Yeah, I know he's a PhD. He's an engineer.
He's got a doctorate of engineering.
All sorts of stuff, and that's hard work.
Yes.
I respect that.
And so, Your Honor, I know we had this discussion in connection with DR degree, and we explained that, for instance, general causation, even he could give this sort of causation opinion and provide that sort of testimony. It was the specific causation, medical causation, where it was an issue. And so, for Dr. Rubchuk, just to be clear, we are not at all trying to present Dr. Rubchuk. We're not going to put him on the stand and have him say, oh, yes, it was this toxin that specifically was the medical cause of Mr. Haley's injury. He's not going to do that. What he has done is, he's basically providing an engineering analysis, a failure analysis, and he's going to testify more about the other type of causation, which is, he's going to talk about, various things that could have caused this overall outbreak, not specific to any individual, but he's going to talk about, root cause failures, things that basically could cause, a lack of disinfection, for instance. It could cause certain, reactions within water treatment programs. And that's the exact same type of thing that Dr. Najm is going to do for plaintiffs. They are not saying that Dr. Najm can't testify. They actually are going to present Dr. Najm, who is not a medical doctor, and he's going to talk about hydrazine being created and whatnot. So, this idea that plaintiffs are trying to force that essentially all of our experts have to be able to give medical causation testimony is just not true. It's not consistent with the case law. So, I'll continue on with Williams. I do want to get to these other cases that come after it. But Williams explained that there were the three ways that the defendant could traverse the plaintiff's case. And it was, number one, cross-examine the plaintiff's expert. Number two, contradict the expert's testimony with his own expert. And or, number three, propose an independent alternative causation theory. And if the defense expert's testimony is used for the purpose of cross-examining the plaintiff's expert or to otherwise contradict the plaintiff's causation theory by comparing that theory to other possible causes, the defense expert does not need to state each individual cause to a greater than 50% probability. And the Williams Supreme Court then explained, quote, therefore, if Dr. Cohen's testimony in docket number 56928 is introduced to contradict the Williams petitioners and the pagan party's theory as to how they contracted hepatitis C by providing an alternative causation theory, then he does not need to testify to a reasonable degree of medical probability as long as his opinion about the alternative theory is relevant and supported by competent medical research. Now, I want to emphasize again that I do think Williams, as Your Honor has pointed out, is the preeminent case that has come down recently on medical causation, testimony from an expert. And as I've said, I don't think that it necessarily applies here. I mean, I do think that it shows that this motion in limine should be denied, but Dr. Rubchuk is slightly different because he's not providing medical causation testimony. And now, what Dr. Rubchuk is going to do is he's going to contradict plaintiff's theory that there was a widespread toxin. So he's also going to contradict their theory that there was a manufacturing issue specific to the real water concentrate. He's going to do that through his own experience, his own specialized knowledge, and his own background, because he looked at a specific root cause analysis, and he did his own engineering failure analysis, and he's going to explain why, based off the failure analysis, there couldn't be this widespread toxin. He's going to explain why, based off his failure analysis, that there wasn't this sort of manufacturing issue specific to the real water concentrate, but instead there were all sorts of manufacturing issues specific to other aspects, such as the Henderson facility's water production setup.
I just have a general question.
Sure.
Where did this root cause analysis come from? And the reason why I'm asking that is this, unless I'm missing something, it's been, I will admit, it's been probably 7, 8, 9 years since I was presiding over construction defect, and we dealt with a lot of construction issues, be it soils, slabs, all sorts of structures, truss, electrical systems, plumbing systems. Plumbing systems was a big one. But my point is this, I don't remember in that area using the term root cause analysis. Did we talk about that?
That's a term that he uses for engineering. It is.
It's very common, Your Honor, in the food and beverage failure analysis.
I understand. But it's my recollection. The only reason I bring that up, I mean, we're using it, but it's my recollection in Nevada. It didn't matter whether it was a soils expert, and we had a few of those cases go to trial. They would opine on potential failures, for example, to a reasonable degree of professional probability, more likely true than not. And they didn't. And they looked to make a determination, for example, as it relates to trusses, whether or not they meet the international building code standards and the like. Things like that. And it's been a while since I've done that. And then under those circumstances, there'd be a determination potentially as to whether there was a construction defect or not under Chapter 40. That's kind of my recollection. So my point is this, we're inserting root cause analysis. And trust me, I've thrown it out there. If that's been accepted and under Nevada law, because I don't remember that being the point or whatever. But go ahead.
Yeah, so that is a common engineering term, and I mean, he did explain what a root cause analysis is or a failure analysis is at his deposition, and I think that underscores our point that he is not trying to provide medical causation testimony. He is essentially explaining his engineering failure analysis that he's performed, and so he is not going to try to say the specific medical cause of an individual's injuries. He's instead going to go through all of the work that he did and explain why he was able to find essentially the failures within the system, and he's going to be able to provide that testimony to the jury. In order to do that, Dr. Rebchuk does not need to be able to identify the specific causative agent. So he doesn't have to be able to say more likely than not that it was microcystins, or more likely than not that it was a specific chemical. He did explain at his deposition that he was able to say it was certain categories of toxins. Now, Mr. Kemp didn't show you that testimony, but and I'll just read them into the record. So,
do we have a copy of his CV?
I do. I don't know if I have it up here, but I can definitely get that for you.
Because I understand his undergraduate degree was he got a degree in mechanical engineering, is that correct?
It was some sort of engineering. He does have here's what I listed. Jim, if you know better.
Is it civil engineering?
I believe it's civil.
His doctorate, Your Honor, is in environmental science. He's a DENB. He's got an MS in environmental health sciences, and he's a professional engineer in 2 states.
He also recently has, I believe, a PhD in engineering, and then he also has an MPH, or Master of Public Health.
The only point I would add to what Mr. Hoffman's saying, Your Honor, I don't mean to jump in, but he is diagnosing not the illness in a person, not the medical condition. He's diagnosing the problem in the facility, the shortcoming in the equipment that allows a product to leave without the critical control. That's what the engineering analysis is here, and that's what Dr. Rebchuk is focused on. Not any medical aspect of this.
I understand. And Mr. Hoffman did a pretty good job of that, explaining that.
I should let him.
No, I appreciate it.
Yeah, but I understood. My question, because I think I said, in a general sense, I get it what he's clearly qualified to do when it comes to potentially system failures at the real water plant. And I mean, I get that. I understand.
That's the opinion.
Yes, that is the opinion, Your Honor. And obviously plaintiffs are going to present their testimony and their evidence about system failures, HACCP, and they frame it in the way that they think benefits them in order to prove their theory, which is the widespread toxin. And all that we're saying is obviously Dr. Rebchuk needs to be able to present his opinions and his theories on why all of the evidence about HACCP and failures and haphazard plumbing and whatnot don't support plaintiff's theory. It actually supports the opposite theory. It supports the idea that in fact, this was not a widespread toxin, but instead it was very specific to just the home and office delivery product. So, Your Honor, and I'll move on from Williams here in a second to the next case, but we certainly believe that excluding Dr. Rebchuk's testimony on these points would improperly shift the burden of proof on causation to the defendant. I cite Williams for that. That's at 127 Nevada at 521. As we've said, even if we're working under the Williams framework, and we obviously have the big caveat that he's not rendering a medical causation opinion, but even if we were, he still needs to be able to provide his testimony on, in order to rebut or contradict plaintiff's theory. And even if it's just contradicting a portion of that, he needs to be able to do that. So, if he's contradicting the theoretical pathways from Dr. Najm, if he's contradicting, their experts' analysis of the HACCP failures and whatnot, he needs to be able to, pick that apart and explain why they have a failure of proof, essentially, on causation. Your Honor, I think it's important then to also look at a case that came out in 2014, which was citing the Williams case, and where the Nevada Supreme Court said that it was essentially confirming or clarifying the Williams decision, and that's the Leavitt versus Seams case, Leavitt versus SIEMS. That's 130 Nevada 503. That's a 2014 Nevada Supreme Court case. In this case, and I'll be brief, I think it comes up in later motions to eliminate. But in this case, plaintiff had sued a physician, Dr. Seams, alleging that she suffered loss of vision and experienced irritation after a LASIK eye surgery performed by defendant. The defendant sought to introduce alternative causation and argued that the plaintiff's injuries were consistent with eye drop abuse. And these are quotes then from the Leavitt case. So, quote, to rebut the argument that the surgery caused Leavitt's deteriorating vision, respondents called Dr. Hansen to testify. Dr. Hansen testified that it was a possibility that use of numbing eye drops caused Leavitt's vision to deteriorate and that the drops contributed to her lack of improvement. He testified that in his opinion, based on speculation, if she had continued to follow his directions, he could have returned her to her best corrected vision, end quote. Quote, his testimony was offered to contradict the plaintiff's expert or furnish reasonable alternative causes to that offered by the plaintiff, end quote. And that's citing, so that's the Leavitt case citing the Williams case, 127 Nevada, 262 P. 3rd at 368. And so again, Your Honor, I mean, the Leavitt case did deal with medical causation testimony. Again, Dr. Rebchuk is not providing medical causation testimony, but I cite this because the principles still apply, and I think that the third case will make this clear. The principles still apply that, as a defendant, UNFW, my client, needs to be able to present testimony, even if it's from an expert, Dr. Rebchuk, to be able to contradict or point out the failures of proof in the plaintiff's theory and in the plaintiff's own expert's testimony. That's what.
Do you have a medical expert that does this, an MD, DO?
We do have a medical expert, and I think that that's coming up.
We do, Your Honor. And again, this has nothing to do with the medical opinion.
Okay.
This is again from Leavitt. Quote, we conclude that the district court correctly applied Williams. In Williams, we clarified when medical expert testimony must be stated to a reasonable degree of medical probability. And then it cites Morris-Ocado. And then it says, we explain that the application of the reasonable degree of medical probability standard hinges on the purpose of the testimony. Then finally it says, quote, once a plaintiff's causation burden is met, the defense expert's testimony may be used for either cross-examination or contradiction purposes without having to meet the reasonable degree of medical probability standard, so long as the testimony consists of competent theories that are supported by relevant evidence or research. And, Your Honor, as we've said, this is not medical causation testimony from Dr. Rebchuk, but nonetheless, it is supported by extensive evidence and extensive research. I mean, he's put together a 62-page report. He has a supplemental report also that he goes through, which is even longer. And besides the report itself, he has appendices and whatnot. So that brings me to a final case that I'm going to show you as I was trying to trace through the Williams decision. And that's this case from 2018. This is, again, the Nevada Supreme Court. This is Matthews versus State. It is a criminal case, it's a criminal case.
Yeah.
It has to do with Levitt.
Is this the Byrne case?
Yes, it is.
Okay.
It is. Was this your case?
No, but I just know about them. I try to read them all.
Yes, and I knew you would. So I think that this one confirms that even though that this framework we're talking about, the Williams framework or Levitt framework, have to do with medical causation testimony, that the principles still apply even where an expert is not trying to provide medical causation testimony. So here, it was a biomechanics expert. It was Dr. Lindsay Johnson, and she was called by defendant to rebut the state's theory and to testify about the mechanisms, of the minor's injuries. This is where someone had been babysitting a minor, and the minor was burned. The state put on evidence that essentially it only could have happened from the individual intentionally burning the minor.
And it specifically dealt with mechanism of injury.
Correct.
Right.
Not with, and we're going to get to that, not with medical causation, which is similar to this case, having to do with Dr. Rebchuk. He is not trying to put on medical causation testimony. Quote, "It is clear from the transcript of the evidentiary hearing that the district court failed to consider the purpose for which Matthews was offering Dr. Johnson's testimony, which was to rebut the state's theory that Matthews intentionally burned CJ," that's the minor, citing the Levitt versus Seams case. And it says, "Indeed, the state presented testimony from 3 experts, all of whom opined that Matthews intentionally burned CJ, including one expert who stated it was, quote, as next to impossible as it comes, end quote, that CJ's injuries were accidental. Dr. Johnson was prepared to testify that it was not impossible and to explain how the child could have tipped the cup and spilled the scalding water on his hands accidentally. The Nevada Supreme Court then explained, in this case, Dr. Johnson's testimony would assist the trier of fact by demonstrating that an accidental mode of injury was possible. Notably, Dr. Johnson was not testifying to medical causation. Rather, the focus of Dr. Johnson's testimony would have been on the mechanics of CJ's injury, which was within his scope of expertise and directly refuted the state's theory. Accordingly, we conclude that the district court abused its discretion by failing to assess the purpose of Dr. Johnson's testimony in the context of the burden of proof when analyzing the assistance requirement, end quote. And the Nevada Supreme Court reversed and remanded the case for a new trial based off that. Your Honor, we think that this directly shows that here we need to consider the purpose for which Dr. Rebchuk's testimony is going to be offered at trial. That's determined by UNFW. That's not determined by Mr. Kemp. The purpose of Dr. Rebchuk's testimony is going to be used to rebut, explain, contradict plaintiff's theory here. And plaintiff's theory, very similar actually to this Matthews versus State case. They're going to basically say that it has to be hydrazine. It's impossible as doing anything else. And, basically that all of their experts and no other experts are going to say that it's anything other than widespread toxin, hydrazine. No other experts are going to say that it's anything else besides this manufacturing failure with the real water concentrate. Well, Dr. Rebchuk is prepared to explain, not for medical causation, but he's prepared to explain for his engineering failure analysis that there are significant holes and issues in that theory in plaintiffs. That essentially that theory could not be true for multiple reasons, including that they're misexplaining the HACCP failures, they're ignoring the other ones when it's convenient for them, and whatnot. Dr. Rebchuk's testimony, because it's going to be prepared and presented for that purpose, should be allowed. So this case obviously was not a medical causation case, as it was explaining here. That's 134 Nevada 512 at Penn Site 516. Nonetheless, the Nevada Supreme Court explained that these same principles apply. So when testimony is going to be presented for a purpose of contradicting or cross-examining the plaintiff's expert and essentially showing a failure of proof in their theory of causation, that it's allowed. It does not need to be to a reasonable degree of medical certainty.
See, I think the big difference in the Johnson case, let me see here. I'm sorry, Matthews versus State and Dr. Johnson. It's my recollection, Dr. Johnson was a human factors expert. And what he was dealing with was essentially there were allegations that the burn occurred intentionally. And he wasn't given a medical causation opinion at all. He was just focusing on the mechanics of how the event could occur, because he was saying, look, this could have easily happened accidentally. That's what, and the trial court improperly excluded his testimony on that issue. But understand this, he was just focusing on the mechanics of the event, nothing more, nothing less, as a human factors expert. In contrast, he didn't testify regarding the burns and whether it was first, second, third degree, whether skin grafts were necessary, or any sort of medical treatment or diagnosis as far as whether the burns were first, second, or third degree, right? Whether they needed skin grafts and all those types of things. So, I mean, I'm looking at it from that perspective, and I understood that because I read Johnson. It's been a long time, but once again, it seems to me it's perfectly in line with all the other cases, because I think what the trial court there did was improperly interpret that he was offering a medical causation opinion and excluded him when he wasn't. He was offering a human factors opinion as to how this accident could have occurred, and rebutted the intentional acts theory of the prosecution, something like that.
Yeah, it lists him as a biomechanics expert, but I mean, it could have been human factors related and whatnot. But you're right, it was the mechanism of the injuries, and you're right that the Supreme Court of Nevada found that the trial court had improperly considered that this was not medical causation testimony, and that instead, is being offered to essentially rebut the plaintiff's, the state's theory there, that essentially, that this was intentional. And I think I agree with you. I mean, it's directly in line with the other cases, and I think it directly proves our point. It's also directly analogous to this case. So, Dr. Rebchuk is not trying to provide medical causation testimony, as I know I've said many times, but he is going to be able to explain why plaintiffs' theories, certain portions of it, simply are not true or cannot be proven based off the actual evidence of what he saw when he did his actual visits to the real water facilities, did his root cause analysis, and then actually also inspected the UNFW facilities. So I think that Dr. Rebchuk's testimony is perfectly in line with what the Nevada Supreme Court found in Matthews versus State should have been allowed, and that the trial court improperly failed to consider the purpose for which it was being offered, and improperly considered it to be some sort of medical causation testimony when it was not.
Tell me this, though, if he offers up a pathogen as the cause of the liver injuries in his case, isn't he stepping beyond what potentially could be a water PhD engineering type opinion and giving a medical causation opinion when he says, look, I think more likely than anything that the problem here was a pathogen, and it's a pathogen that no one's identified.
So Dr. Rebchuk is not going to get up and say that it's any specific pathogen that caused a plaintiff's injury, or that he's not going to try to diagnose any plaintiff with having that pathogen. He's not going to talk about the extent of their injuries from any specific pathogen. What he is simply going to do is give an engineering failure analysis that talks about things such as a failure of disinfection. He's not going to try to connect it, and that is actually something that is the subject of other motions with other experts. So I can assure you that he is not going to attempt to give any medical causation testimony about a specific pathogen. So to close out, I do want to address Mr. Kemp also brought up the Wren theory and these types of things, and I know we discussed that extensively with MSJ number 1. So I don't know if the court wants me to go back through all the evidence that's contradictory to plaintiff's theory on that. Just briefly, I'll just say it. Lane Jones, for instance, testified, as I know the court knows, that the move to Henderson had started before the eviction proceedings had started. That's testimony that was directly shown in the argument for the MSJ number 1. We know that means that if the move started before, that essentially we know that the move was happening or happened before Wren ever got it, even according to plaintiff's theory. So obviously there's disputes of fact there. This is disputed evidence. I know that that's the subject of a separate motion. But in any event, disputes of fact are not a ground to exclude an expert's opinions. So, and I pulled 2 examples here directly from Williams and Levitt. Williams talks about it. This is at 127 Nevada at Insight 530. And it's the Nevada Supreme Court noting that concerns about the reliability of the expert testimony go to weight, not admissibility. Same thing with Levitt. Quote, in Levitt, we further conclude that Dr. Hansen properly testified as to his opinions and inferences to rebut Levitt's theory of causation, and that even if portions of his testimony were speculative, it was for the jury to assess the weight to be assigned to his testimony, citing NRS 50.305, and then also Houston Exploration Inc. versus Meredith, that's 102 Nevada 510, which was explained in the context of a challenge to expert testimony is speculative that is for the jury to determine the weight to be assigned such testimony, end quote. I just mentioned this because obviously what Mr. Kemp wants the court to do is to decide disputes of fact in their favor, then exclude an expert simply because the other side's expert is talking about the other side of those disputed facts. That is not the proper subject of a motion limine. I mean, we briefed it and we argued it. I don't think that's also the proper subject of a motion for summary judgment. But in any event, it's certainly not the proper subject of a motion limine, as both Williams and Levitt explain. So, Your Honor, with that, we do think that Dr. Revchuk needs to be admitted here in full. Obviously, as the court has seen and stated, there are significant other opinions throughout his 62-page initial report and his significant supplemental report that need to be admitted in any event. But excluding even his discussion of the failures of disinfection or whatever plaintiffs are going to try to convince you to exclude would improperly shift the burden of proof to UNFW, the defendant, on the issue of causation. The plaintiffs here must ultimately persuade the fact finder that UNFW's conduct was more likely than not.
I want to make sure what you're saying is this, Judge.
Yeah.
You're saying, look, we want to offer up an alternative theory to hydrazine as being the cause of the liver failures in this case to some unknown pathogen?
I think that misstates it. So, first off, what he really is going to do is he's going to explain, number one, why the hydrazine theory that the plaintiffs have and seek to present to the jury does not work. So that's the first one. So he's showing that they actually have a failure of proof, number one, on causation.
So how would he handle that? I mean, I respect his engineering abilities, I do, but this is slightly more nuanced than that, because I think at the end of the day, it's going to some of the processes in place as it pertains to the ceramic titanium tubes and the other chemicals that were being utilized by real water in their production. Right? And so he's going to say that it wasn't hydrazine, it was some other unknown pathogen that we have no evidence of.
Well, we do.
Is that what he's going to do?
So I've explained, and I stopped briefly in case Mr. Neale wanted to speak up, and I hope he does. But
no, you're doing a good job.
Okay. So number one, he's going to explain a failure of proof in plaintiff's theory. So he's going to explain why they cannot prove causation, and why what their plaintiff's theories of what they're saying, this widespread hydrazine theory, simply does not work when you look at the actual engineering of it. So when you look at the engineering failure analysis, it cannot be this hydrazine only theory that, this is widespread and it's limited only to what plaintiffs want to say is the manufacturing issue with the real water concentrate. So that's number one, what he's going to do. And I think that that's directly allowed by Williams, Levitt, and Matthews. The other thing he's going to do that Your Honor is getting to is he's going to talk about what could happen essentially if you have these engineering failures that he noted. So he's not going to talk about a specific pathogen being the medical cause of any plaintiff's injuries. That's something that other experts can do, actual medical doctors. But he is going to talk about, for instance, if he finds a failure with the HACCP, if he finds a failure with ozone, if he finds a failure with UV, if he finds a failure with their pump, which he documented. And these are just 4 of the examples. I mean, if I go through, he's had about 20 to 25 different specific failures that he found in his in the water production setup at Henderson. That essentially there could be a failure of disinfection based off that. And he gets into what that means. He talks about, for instance, even in the excerpt that Mr. Kemp showed you, he explained that ozone itself is a disinfectant and that it's a highly reactive chemical. That's directly from what Mr. Kemp showed you. That's pages 23 to 25 of his transcript. He could explain that even ozone could react with hydrazine, for instance, if plaintiff's theory is true. And if hydrazine is in there, it could get rid of it. But if the ozone is not working, it's not going to be disinfecting. It's not going to be reacting with anything. It's not going to oxidize anything. So that's an example.
Were the same processes in place at was it Desert Inn? They just moved the...
So they were not the same processes, and that's what he will go through. So he has the documents. Obviously, no one has had the opportunity besides, Real Water and the health departments to inspect Desert Inn. It was closed down by the time of the recall. Obviously, the equipment had been moved to the Henderson facility. Now, what Dr. Rebchuk has been able to do is to take the documents from Real Water, the pictures that they have, the maps, the HACCP, SOPs, and other documents, and he's been able to show that there are actually very specific differences between how it was set up at Desert Inn and how it was set up at Henderson. So, for instance, at Henderson, and there's testimony on this, it was very haphazard because this is basically what Anthony Brown explained to me. It was during the pandemic, and there was a little boom for home and office delivery Real Water. Everyone wanted home and office delivery Real Water. They did not want to buy the retail bottles anymore. So basically, Real Water was under the gun. They had to move the facility haphazardly, as quick as they could, to the Henderson facility. They packed it up. Apparently didn't connect some of the equipment and whatnot, including the ozone and the UV, or perhaps it got moved first to Mesa, Arizona, as that one got set up. But in any event, Dr. Rebchuk has identified very specific differences between how the Desert Inn facility was set up and how it produced 5-gallon water up until close to the end at least, and then how the Henderson facility was operating. So clearly something, and this is not speculation, I mean this is not anything that we've come up with, this is actually what the health department believes. This is CDC, FDA, and Southern Nevada Health District, and in fact, I deposed Lauren Dupree, the environmental health specialist from the health department, and she was designated as the 30B6 witness. She explained that their theory is that something happened with this move. That basically this equipment was kind of dismantled, the UV or the ozone or whatnot taken apart when it was moved over. That there was an issue, and she actually did a full map of the water production diagram of it. I took her through it, and she explained and confirmed that the things that Dr. Rebchuk noted at his inspection of the Henderson facility were true based off her inspections on behalf of the health department. So she did not find an ozone hooked up. She could not find any UV lamps hooked up. She saw that essentially at Henderson, specifically, Real Water was not following its SOPs. It was not doing any sort of testing. It was not doing any of the other requirements that it was supposed to be doing. So there are very stark differences between the setup, let's say in 2018 at Desert Inn versus Henderson in late 2020.
So are they trying to say that this was somehow bacterial or something like that?
What do you mean by that? Are you saying, Doc?
The expert, this pathogen, bacterial in nature, and the reason why I asked that many times, if it was something that like that could have been tested when the patients were having the blood work done and all the things that doctors typically do from a medical perspective. They can test you for pathogens and those types of things, because the things you're talking about, it seems to me, and listening to, because I was listening, the types of safeguards that would have been in place potentially would have gone to some sort of bacterial problem, maybe on some level, some sort of problem with mold or other contaminants, but they can kind of trace that.
So what the health department has explained is, and this is in the presentations as well from CDC and FDA, is that unfortunately, and I've seen presentations from Dr. Ruff, who's the head of the investigation on behalf of CDC, FDA, and whatnot, and she's explained that most of the potential hepatotoxic agents would essentially degrade after time, and they're not testable after some amount of months. So, there are various ones that have been discussed with the health department individuals and with other experts, such as NDMA, with an N, as in Nick, not MDMA, but NDMA. That's one. That's a chemical agent. It's an example. There's microcystins. There are other examples that they believe, could be an option, but essentially none of those could be tested. That's the problem. So essentially they would disintegrate over time. It's not possible to be able to test those after some amount of months, to go back to older water samples and test for it. So,
but what about the patients themselves?
So those are also not testable in the patients, other than they cause liver failure. They cause spikes of the liver enzymes. And
the only reason I bring that up, because a couple of the agents that were mentioned by Mr. Kemp, for example, from a medical causation perspective, and I think it was one Giardia and cryptosporidium or something like that. Those don't cause liver injuries.
Yeah, so Dr. Rebchuk was asked extensively about this his deposition. He explained that ozone is not specific to those two, Giardia and whatnot. He explained that in fact I think he called it a broad spectrum disinfectant. I wrote down the sites here. That's on pages 23 to 25 and pages 27 to 28 and page 30 of his deposition. He's asked 3 separate times. He explains that essentially ozone and these other various components of Real Water's system that should have been hooked up, but they were not, are essentially broad spectrum, and that essentially they would react even with chemical agents such as hydrazine. He said that essentially anything that could oxidize, these things would break it apart. That's what they're designed to do. Is the ozone is specifically designed, and that's why it's used for water production, for bottled water, is because it is a broad spectrum disinfectant, and that it actually would react both with bacterial agents and also chemical agents, in the words of Dr. Rebchuk. Now, he's not going to, and I just want to be clear, because we got into this conversation about specific medical causation and if we can test patients' livers and whatnot. And I want to be clear, Dr. Rebchuk is not getting anywhere close to any of that. I just was responding to the court's questions.
No, I understand, because that's what Nurse Hambrick tried to do in the scope room in Williams.
And Dr. Rebchuk is not going to try to do that here.
Yeah, right?
No, Dr. Rebchuk is going to do his engineering failure analysis. He's going to talk about, what these failures were from his own personal observations, as well as his extensive review of the records. He's going to talk about, what would happen here? What would happen if you had a disinfection, issue here, based off of no ozone, UV, a pump failure, HACCP violations, and the various other 20 to 25 failures that he explicitly listed in his report. So, Your Honor, we do believe that all of his testimony should come in. We do believe that excluding any portion of this, such as this engineering failure analysis, would shift the burden improperly to defendant in order to prove that essentially defendant's conduct was more likely than not the cause of the injuries. So, with that, I'm happy to answer any other questions the court may have. If you have any.
I'm fine for now, sir. Thank you.
Thank you, sir.
Do we have some jointers? Anything you want to add? Okay.
think there were on this one, Your Honor.
Okay.
Your Honor, the primary problem here is we don't have a medical doctor endorsing this unknown pathogen. When you asked that specific question to the defense, and they threw you a curveball. They said, "Oh, we have a testifying doctor, which is Dr. Dara." Well, they didn't tell you that Dr. Dara is rendering an opinion on the Belsky case, 2018, the Haley case, 2019. Neither one of those cases can possibly have anything to do with unknown pathogens being generated in the Henderson plant in the fall of 2020. You know, temporally, that's at least 2.5 years and 1.5 years away. So Dr. Dara, and we're going to go through her opinion in the next segment, but basically she blames turmeric on Haley's case, even though it's one of the most widely used supplements in the United States, and she blames kratom on the Belsky case. Okay, even Dr. Dara doesn't go down the road of unknown pathogens with regards to those two particular plaintiffs. So the point is, they have no medical doctor to testify that there is an unknown pathogen that could potentially cause acute liver failure, to testify, as he suggested, that it wasn't found because it disappeared.
Well, I mean, that's a really important point,
Right.
because whether the pathogen's chemical, biological, whatever, certain pathogens attack the kidneys, some attack the heart, some attack the liver, other organs in the body, some leave the liver alone. I mean, and that's why you need a doctor for that purpose.
Right. In Morsicato, we had a doctor trying to give the theory for the pharmacy. In Williams, we had a doctor, and Dr. Cohen, that was allowed. And then we had a nurse, and like the court alluded to, the nurse was pretty qualified, really, to be honest.
He was peer-reviewed,
He was
published.
peer-reviewed. He was actually published on Dirty Scopes. And he gave lectures to the American Gastroenterology Association. So he at least he was in the medical field, okay? I will say that. In the Seams case, versus Levitt, again, we have a doctor. So what they want to do is they want to have this person who's not a doctor say that there must have been is what is really bad, an unknown pathogen. Okay, but even if he's right, so what? There's no one there to tie it up to any of the plaintiffs. Because the four plaintiffs that drank from 5-gallon jugs, Ryerson, Bottiz, Arnone, and you, they don't have a doctor that's rendered an opinion on any of these four cases. The defendant, none of the other defendants have a doctor on any of these four cases because we've excluded Dr. Tanner. So, Your Honor, there is no way for them to link up this purported engineering finding with medical causation. So they can't say it's going to rebut Dr. Hudson or it's going to rebut Dr. Friedman. It's not testimony from a doctor, and that's what's absolutely necessary. Now, you know, they say, oh, this isn't medical causation. Your Honor read the focal point of that. Chris, can I have his report, please? Can you do that, please? This is so much worse than Morsicato, Williams, and the Seams case, because they're not trying to present this as an alternative cause. They're just trying to throw this cause out there to allow the jury to wildly speculate that maybe this is a cause. We have his opinion 1 through 11. Okay, there you go. There you go. Okay, opinion 1. We'll blow that up a little bit. He says that the 5-gallon production facility was the geographic origin of the acute nonviral hepatitis outbreak. Well, maybe an epidemiologist could say that, but he is not an epidemiologist. Let's see 2. From an engineering evaluation perspective, a liver injury caused agent has not been identified, but based on the evidence gathered during my inspection, and then he goes on and on to facilitate the presence of spread of caused agents. This is pure medical causation. That's all this is, Your Honor. It's cast in terms of an engineering evaluation, but it's medical causation. Now, if they wanted him to testify about the potential creation of a pathogen and then hand the baton off to another expert, a doctor, to finish the race, that would have been one way to do it. But they couldn't do that for a couple reasons. One, they didn't designate an expert to look at these cases. As I said, Dr. Dar limited himself to the other cases. And two, they couldn't find a pathogen. So here this guy is going to say that there's an unknown pathogen among 200 potential pathogens, doesn't know whether it causes acute liver injury or not. There's no objective evidence of it. We can't test the science on it because we don't know the name of the pathogen. We can't analyze dosing on it because we don't know what pathogen it is. I mean, some pathogens, I think the classic example is Ebola down in Africa. You're exposed to that, you're in big trouble. Doesn't matter how much exposure you get. Okay, other pathogens, you need some serious exposure before you have a problem. So we can't analyze that because it's an unknown pathogen. We don't even know the name. So take a look at his next opinion. It's free. Okay, this is Casey Aikens. Maybe you can give this opinion, Your Honor. And I'm not saying that this expert should be totally excluded, and I'll get to that in a moment. But I do think any mention of unknown pathogens, any association of unknown pathogens with any piece of equipment, and any suggestion that an unknown pathogen was the cause of this outbreak should be excluded from this particular witness. And that's really what the motion addressed. Next one, Chris. Next one. Okay. So he says that he's giving an opinion on the cause of the outbreak. Again, he's not an epidemiologist, Your Honor. He can testify on HACCP. I haven't argued that. He can testify that Dr. Najum, the world's leading authority on hydrazine, is an idiot, doesn't know how the hydrazine was formed. That's fine. I'm not challenging that, okay? He can testify to that. But he can't come in here and give opinions that there are either an unknown pathogen or that pathogen was the cause. And, counsel tries to run to the Southern Nevada Health District and say, oh, they support our pathogen theory. That's not accurate, Your Honor. The Southern Nevada Health District considered a lot of different theories. In fact, they specifically said that one of the theories that they thought merited consideration was that there was a problem in the concentrate. And again, you have to remember, this is before that FDA testing came out in October that identified the hydrazine in the concentrate. So even before they knew hydrazine, a substance that people all concede causes acute liver failure, even before they knew that, they were looking at a hydrazine problem. Can we have Mr. Preet's testimony, please? Or Dr. Preet, I guess it is. Chris, that's 128:14 through 22. Okay, this is Dr. Preet. She's the Southern Nevada Health District person that Mr. Hoffman mentioned. One of the theories or issues of discussion about how this toxin was getting introduced into the real water was through the making of the E2 concentrate, correct? Answer, yeah, it was a possibility that we were curious about. Yes. And this is before they knew that the concentrate had a toxin in it that caused acute liver failure. So, really, it's as I said at the very beginning. He wants to say that there was a pathogen that, quote, had to have been present, unquote. Can't say what it is. Can't say whether it's a pathogen that causes acute liver injury. Since we don't even know what kind of pathogen it is, we can't analyze, the mechanism of action, how much you need, dosing, anything. And they say, oh, he's not, this is a direct quote from Mr. Hoffman, he's not purporting to give medical causation testimony, unquote. That's exactly what he's doing. He is throwing out a potential medical cause for the jury to consider without any kind of linkage by a real doctor, or a doctor rather. But this is medical causation testimony. It's just the first part, the potential causes. And you know, the only difference between that and the other cases, like let's go back to Morsicata, at least they had a doctor in that case, and at least that doctor had potential alternative causes that had names. They could name the potential alternative causes, and those causes, there was an analysis done whether the scientific literature supported the fact that they would cause the type of injury that Andy Morsicato had. But this guy just wants to throw out unknown pathogens that were the cause of all the injuries at Anderson. And you know, I think the difference between this and the hydrazine is striking. There's objective evidence of hydrazine, no evidence of the unknown pathogen. They tested the retail bottles. They found hydrazine. They didn't find any of these unknown pathogens. You know, and they looked for them, Your Honor. We asked the Eurofins guy whether he found anything else that could explain acute liver injury. He didn't, but they looked for it and they couldn't find it. And now they want to put this unknown pathogen in the mind of the jury as a potential cause. You know, some jurors, they sit there and if you throw mud on the wall, they look at the mud. Some jurors are just like that, Your Honor. And I said earlier that there are permissible rev check areas. You know, I don't think we really object to him saying that the real water plant was not HACCP compliant, because our theory is that UNFI should have sent an inspector in there to see, and they would have seen that the plant was not HACCP compliant. So even though it's a different plant, I think that kind of supports our theory, not their theory of the case. So we really don't mind him saying that. And I don't mind him disagreeing with Dr. Nash on how the hydrogen was formed. I mean, there's no dispute that it was formed because they found it in the concentrate. But if he wants to debate Dr. Najm on that, great. So have him come in here and testify about HACCP problems. Have him come in here and testify that Dr. Najm doesn't get it right. But he can't give testimony that an unknown pathogen was the potential cause. Just can't do that. And so for that reason, Your Honor, our motion should be granted.
Your Honor, before the court considers what the last part of what Mr. Kemp said, I don't believe the opinions include from Dr. Revchek any opinion regarding the last opinion that Mr. Kemp said he thought that Mr. Revchek could offer. I don't believe he does question hydrazine formation in his report, unless it's in his rebuttal. I have it written here. I don't see that here.
I think Mr. Kemp was referencing what I read, which was from his deposition transcript where he discussed that at the deposition. I think it was starting at page 46.
Okay, I appreciate that, Mr. Hoffman. I don't see it in the report, Your Honor. So of course, I always refer back to what Rule 16 provides, 2B. And so perhaps there was a discussion at the deposition. If there was no foundation for that position, then of course under 16.2B it would not be allowed. The only other thing I would mention, and I think Mr. Kent was being very generous and gracious in this part of his rebuttal. If the testimony of Dr. Revchek is simple, or an opinion of his, again tries to go to causation, because there were 2 or 3 more opinions that Mr. Kemp didn't get to. The word cause is included in those opinions. If they're leading to his causation opinion, again, those opinions would not be suitable for this witness. So I just want to make sure I put that on the record, because I know we didn't get to the other opinions. And I know the causation issue, the court's very familiar given the Williams case, the Hallmark case, the Seams case.
It actually goes back to even Brown versus Cavanaugh.
Yeah.
I decided in one of those cases.
That's right.
That was my partner's case, Roy Smith. I remember we tried that case.
That's right.
Ned Mount, defending Dr. Cavanaugh.
That's right. And so I just wanted to make sure, because like I said, I think Mr. Kemp was being very generous in his last remarks. If it's not supported if it's not in compliance with 16.2B, and it goes to causation, which no one's allowing this type of physician, this type of engineer who's not a physician to give causation opinion on.
This is what I'm going to do, and I think it's important to really go back to the report. And I'm looking at page 1 of the report, assignment and retention, this is what Dr. Revchak set forth as part of his retention and assignment. On behalf of United Natural Foods Incorporated, a wholesale distributor of retail-sized real water, to conduct an engineering root cause evaluation into the probable cause of liver injuries outbreak. Yes, sir.
I'm sorry, I didn't interrupt.
Oh, okay.
Not liver injuries. The cause of the outbreak, which is a liver injury outbreak.
Okay.
He's merely describing the outbreak, Your Honor, not the injuries.
And I'll be fair. I'll go back to it. To conduct an engineering, I need to get better glasses. To conduct an engineering root cause evaluation into the probable causes of liver injuries outbreak associated with real water, alkaline water product, period. Did I read that right?
No, sir. He's not saying cause of liver injuries.
But that's what he says. Did I read it right? Right here.
I'm sorry, Your Honor. It shouldn't be plural. It should be. He's describing the outbreak, the cause of the outbreak, not the cause of any individual's liver injury. We understand the distinction very, very clearly.
Well, I understand. I'm just going off as
You're right. You read it correctly, Your Honor.
I don't
You did.
understand the interruption by Mr.
And I apologize for the interruption.
That's okay.
I was mistaken.
Yeah, you read it correctly. We have it right here.
No, that's okay. We want to make sure I get it correct. I'm not holding that against anyone. I'm not. This is a high stakes case. It's very important. It really is. Anyway, and the reason why I bring that up, there's a couple other areas I want to go to too, and then I go to, and I understand the unknown pathogen theory. Then I look at opinions 1, quote, the Henderson 5-gallon jug production facility was the geographic origin of the acute non-viral hepatitis outbreak. Despite robust public health case finding efforts, no liver injuries were found to be associated with the consumption of retail-sized bottled water elsewhere, period. Opinion number 2, from an engineering evaluation perspective, a liver injury causative agent was not identified, but based upon evidence gathered during my inspection, real water, Henderson's 5-gallon jug facility had numerous severe engineering, disinfection, and sanitation deficiencies that would facilitate the presence and spread of causative agents via 5-gallon jug home and or office delivery product, period. And here's my point. And I do feel that Mr. Revchak is impeccably credentialed. However, he's not a medical doctor. And any issues regarding medical causation, opinions on unknown pathogens that potentially could cause liver injury that couldn't be identified, he's not qualified to testify about. Right? He's not. He doesn't meet the qualifications requirement as set forth in Williams. And I think that's what's problematic about his testimony as it relates to unknown pathogens that were never identified. And just as important, and this is one of the things that's talked about in Williams and many of the other cases, even if he was a physician, right, MD, and he tried to offer up unknown pathogens, that wouldn't stand. There has to be a foundation for that opinion, right?
Medical.
Yes, it has to be competent, right? And so, but to me, it's a fairly straightforward call as far as qualifications, right? He's not qualified to opine on these issues. Now, so what I'm going to do is this, and regarding any medical causation opinion he might have regarding unknown pathogens, causes of liver injury, and those types of things, I'm granting a motion. Just want to make sure it's clear. as far as, and this is a little fuzzy, as far as the full extent of it, but medical causation's out. Independent alternative causation out. Anything regarding unknown pathogens out. There's not even a foundation for that. And as it relates to, and I don't think this was the thrust of the motion. For example, production issues, maybe, right? But when it comes to medical causation, unknown pathogens, and liver injuries, root cause analysis as it relates, evaluation into probable causes of liver injuries, outbreak associated with real waters, alkaline water products out.
We understand the rule, Your Honor. Thank you.
Okay. All right, let's go to the next one.
The next one involves Dr. Dara. It's number 23. I think that'd probably take more than, I'm guessing it'll take about an hour and 10.
So what are we doing? Getting one morning, one afternoon
I was
done?
going to suggest that rather than starting that one, get halfway done, we knock off a couple quickies. Or
Okay.
maybe quickies. When I talked to Mr. Rasmussen, that was like number 30, which was the next one after this one. And that's plaintiff's motion was number 30 to pre-admit the YouTube video of Blaine Jones. That was the YouTube video that we saw earlier today. And so he filed a motion to pre-admit it because we think it would be helpful to show portions that both sides. I'm sure Mr. Rasmussen would want to show something too. But we think that's a good little video that explains the function of it all.
A function of,
The OR meter.
okay.
That shows you. He sticks the probe in there. It shows the numbers changing. So that's one of the reasons we wanted to admit it. Their objection was not so much to relevance, I don't think.
No.
Because they like parts of it too. But their objection, I think, was to timing. They wanted to admit it later in the case when Mr. Jones testifies. I just think there's no reason not to admit it up front. I think it'll really help the jury to understand what an org meter is because the pictures worth 1,000 words, the videos worth much more than that. And so that's really the basis of our motion.
I think this is a quick one as well, Your Honor. I'm still opposed to pre-admitting it, only because it needs to have a foundation from someone. Mr. Jones is not a chemist. We don't know how he came up with these opinions with regard to this and how it was used.
But he was real water, right?
He's with real water, yes. Okay, we don't know. We don't believe that he was using it correctly, and so that's the reason why we wanted to say, hey, we don't have an objection to it being relevant. We don't have an objection to coming in. We don't have an objection to anything else with regard to that, except that we need him to say, what were you doing with this? Why was it here? Lay that foundation as to when it happened, why it happened. This was done, we believe.
Wasn't this part of their advertising? Was it?
Yeah, well, no, it was about their training for their sales staff, and we think it was done like 10 years before this outbreak, or thereabout. We don't know these foundational questions, and I think that those things will be important for the jury to hear as to how this came apart, how this came about. As I say, this picture's worth 1,000 words, and you can just accept it as being true. That's why I'm saying is we ought to find out all of the background of it when Mr. Jones is going to be there to testify on it. Otherwise, it lacks the foundation and relevance to anything happening with the people that are here in this case. And that was my objection. That's all I've got for it, is that I'd really like to see it come where Mr. Jones can tell us, what is this? When did you make it? All those questions with it. None of that was provided by Mr. Jones. Okay.
Well, Judge, I want to argue that just a little.
Okay.
First, I'm going to start with.
Wait, does anybody else have Mr. Odou, use your?
No, Your Honor, we've taken no position on this.
Your Honor, Mr. Rasmussen said this was for training employees. I think that the testimony in the deposition was it was for pretty much a roadshow for co-packers is what he was using.
This was the sales staff. They each one got their own ORP.
They were going to other states and they were showing this video. They were trying to get other people to agree to become real water co-packers. That was really the purpose of the video.
Real water, what?
A co-packer means someone else who is packing the product along with them.
I understand.
Like a water bottle, another water bag, I don't want to use Tennessee for an example because I'm sure that'll go to a bad place, but they were trying to induce other people to make the product like they were in different states. And then I think there was also some part of it that Mr. Rasmussen's right on. I think they were using this a little bit for the training. But his testimony, and you can see when you compare that video with Kurt, yes, Mr. Jones, that was a while ago. And he said, I think he said in that deposition that it was about 2014 they made that. We know it had to be 2017 because they discontinued the cleaning solution in 2017 because it was giving people cancer. So it had to be before that time. Yeah, that was 2017. So we know it had to be before that time, Your Honor. But I do think he gave a date. And I don't see the problem in introducing the video and letting the jury see it at the outset, because like I've already said, I think it really does explain how the meter works better than anything I could do.
I mean, go ahead.
You're willing to go, but the reality is I think it should be done when someone is here that can actually lay the foundation for the evidence. And he won't be here to do that, and I would like to see that happen.
But he did lay a foundation. He said he made the video, he explained how it was made, gave us the basic reasons, told us to his best recollection.
Doesn't know when?
That was him in the video.
Doesn't know where? But you do what you think you're going to do, and I'll live with that, Your Honor. Thank you. I don't think it has the foundation, and I think it's very simple to have Mr. Jones come in and say, what is this? When did you make it? What has it got to do with things?
What was he asked during his deposition?
In his deposition, he was not asked those questions. When did this come about? Wasn't asked.
Was it referred to in his depo?
Yeah.
Asked about?
Yeah, but not in those details. No. Yeah. It was, and let me explain to Will Kemp so he understands. He wasn't aware, I don't believe Mr. Kemp was aware of this video until we showed it, and then he saw it in the deposition for the first time. So I don't know that he was prepared at that time to figure out what this was all about. And it wasn't until after the deposition that a lot of the stuff should have come out. We were going to use it at that time to talk to Mr. Jones at that time about this. Did you make this, that sort of stuff? We know it's Mr. Jones on there, I get that, but all we want to do is say, okay, when did you make it? For what purpose? Why did you do this? These things are still up in the air. It's just a matter of foundation. Do I have the foundation for this video? The answer is no, we don't have it all. So if we could just have Mr. Jones there to do it with, I think is better than just admitting something without that. Pre-admittance is really about, do both sides agree that it's okay to use this? Can it still come in an alternative fashion? Yes. How? Reasonably with Mr. Jones.
Your Honor, have you heard?
Absolutely. It's a pleasure.
I don't really oppose the pre-admittance of the video. What I oppose is any speculation, and I join in Mr. Rasmussen's comments about the lack of foundation. My client's not a co-packer. He's an Eastern United States manufacturer that employed a co-packer in Pall Mall, Tennessee. So to the extent there's some suggestion that this was that Blaine Jones knew anything about what Tennessee's Real Water of Tennessee was doing, I object to it. In fact, in deposition, he testified explicitly, Blaine Jones, had no knowledge of what was going on with my client on the East Coast.
He could remember this video, just so you know. He
But,
showed it to him and says, yeah, it's me, but I don't remember doing it. Because it was 10 years ago.
And again, I don't oppose the pre-admittance of the video. I'm just what's been maybe mistakenly characterized as having anything to do with the Real Water of Tennessee, and which was not a co-packer. It employed a co-packer.
As Mr. Pepperman pulled up the testimony, and I did lay a foundation for this, so let's go back to the first page.
Page 101.
Can you put it up?
Yeah.
Okay. Even better.
Starts at 9:21.
101, line 21. Question. Okay, so we have Exhibit 34, and that's the excerpt made from the video. And that excerpt, again, is the thing with the chart that says dip it in vinegar for 5 minutes. Question, did you make a YouTube video? Answer, I did. And the purpose of the video was to help explain to people. Well, maybe I should ask you, what was the purpose of the video? And then let's go to his answer, please. Because that's a little over 10 years ago, more than 10 years ago. I don't remember exactly, what it was, but my understanding, I was the best remember, it was kind of how to show and test the product for pH and ORP and kind of demonstrate the difference between real water and other bottles of water. And Your Honor, you've seen the video, he does that. Next, please. Eric. Okay, if you look, I want you to look at the transcript. We prepared a transcript of the video and gave it to him. And you say, quote, I've done hundreds of product demonstrations over the last year. That's what he said in the video. Did you do hundreds of product demonstrations over a 7-year period? I go, which page you're on? He says, I'm on 35, exhibit 35, line 6, page 2. So he looks at the transcript and he says, yeah, for a certain period of time I was doing these product demonstrations, traveling all around the western United States. At the time you did the product demonstrations for the Little Blue concentrate, to clarify, Your Honor, for a while they made a little blue bottle and they were selling. What?
It just says no, answer no. Right.
Okay, well, they made a little blue bottle, and the blue bottle was being sold separately to make your own real water. Amen. So I asked him if he's doing the demonstration for that, and he says no, he's doing it for real water. I go, the little blue ones, and he goes, no, the liter ones, 500 milliliter. And we go on, go through the whole transcript, and did I read it right? Yes, keep going, please, Chris. Give us a little more. Next page we go through. So basically, we're discussing the YouTube videos how to calibrate the ORT meter using the oxygen calibration kit. Again, that's a reference to the 2007, the product that was discontinued in 2017. It goes, looks like in the video, exhibit 34, we go to the box. So we read what's in the box, which is what I referred to. Instead of calibration solution, you can use white soap vinegar, soak for 5 minutes, rinse in good water. So we like that because he's representing that you should put it in vinegar for 5 minutes, not the 5 days that you should do it when you, I'm sure use the right word or I'll get jumped on. Condition product. Okay. So, and then we go on and on and on. Who made the video? He doesn't remember. There's a company called Real Abundance that was, I guess, part of the production process. But I don't know what more foundation I have to lay for this video at this point. I mean, we've gone over, I think this is the 4th page I'm laying foundation on.
And I just want to make sure what was his position with Real Water?
He was the executive vice president.
Not at this time, was he?
I don't want to say for the record. I think he was an officer, but I don't know I don't know. In 2013, he was an officer. I don't know that.
Yeah, but I'm talking about when his deposition was taken.
He was executive vice president.
And you've already designated him as a
How did you know I was going to go there? That was my next question.
That's exactly right, John. I told Mr. Kemp that a little while ago. We didn't say it soon enough. But yes, John, that's exactly right. That's one of the first motions we had the first week of July 24th.
So, what does that do to the analysis?
Nothing in my opinion. Says I didn't make it. It wasn't my stuff. It was done by somebody else.
But that's him.
That's okay. That's what he just said about it. I don't remember doing it. But, you'll do what you need to do. That's fine.
No. But there has to be
He's there to be able to give you this foundation. He's going to be testifying. Is there a reason that we need to pre-admit it at this point when he's going to be there? We have an alternative that's just as easy, and that is, what is this?
Well, it really comes down to what are the rights of the parties under the rules. It's not what I want to do. He's the managing speaking agent on behalf of the defendant, Real Water in this case. We can all, that's true.
That's right.
Secondly, potentially is a statement against interest. Third, pardon?
He is a plaintiff in the case.
He's a plaintiff?
Yes. Not in this case. Oh. And I thought the bankruptcy held up that whole decision anyway.
Yeah. But I mean, whether he's a plaintiff or not, he's the managing speaking agent for the defendant, right?
That's correct.
We'll see.
No, is he?
I don't know, Your Honor, since he's a plaintiff in the
Designate
case.
him as such, yes. Your Honor has granted plaintiff's motion, to designate him as such, yes.
Okay.
Yeah, I don't know why.
But was he a vice president when this deposition was taken?
Yes, Your Honor.
Yes.
Right. Okay. I mean, and this is his deposition.
Yes.
He would be a party opponent in this case.
Yes.
Correct?
Yes.
Right? And I'm just going through either he would or he wouldn't.
He's a party and a party opponent, Your Honor. It's the
I
strangest thing.
didn't know about that. I seriously didn't know about that. Interesting.
Yeah.
So too.
Interesting. What about work comp and all that stuff?
We have lots of things to look on that. Comparative liabilities.
We don't represent them.
Okay. But I mean, I think he's a manager.
He resigned
Yeah,
in March
I'm
of
gonna
2020.
pre-admit it. It's
Your Honor, another, I think a quick key is,
Now, I just say this, it's 4:35, and we didn't take a single break this afternoon, as long as the staff is okay, y'all. I need to go.
they're not okay. Ready to go.
I was wondering,
All right, we'll just do one more.
okay, Your Honor, this one's 34.
I didn't realize
Is
we
to
were-
preclude reference to room painting as a potential cause of liver damage in Mr. Belsky's case. Mr. Belsky, prior to going to the hospital, he had painted a room in his house. And so when he went to the hospital, they were trying to figure out what's causing your liver injury. And the emergency room doctor made a note in there saying, well, maybe it's the room painting. Since that time, the defense experts don't think the room painting was a cause. And we ran down the exact paint he was using and provided it to the defense runner. We got the exact paint, the brand, what was in the paint, and we gave it to them to try to keep this issue out of the case.
Was it a Home Depot type Valspar?
Reserve, Your Honor.
Okay.
Wear a ventilator if you use it. That's my
But in
recommendation.
any event, Dr. Dara, their expert, excluded this painting as a potential cause. There's no expert testimony that's going to say it's a cause. So we filed this motion to preclude room painting as a potential cause. Their opposition was, great, you're right. Our experts aren't going to say it, but we still want to get in the ER record, okay? And the ER record has the opinion of the ER doctor, or too much to say it's opinion. He lists a potential cause of this room painting. And that's it. Sees him one time in the ER. I want to see someone in the ER. And I don't think we know the name of the ER doctor, but later we got an ER doctor's opinion saying room painting. The ER doctor wasn't designated on the witness list. There's been no report filed from the ER doctor, no resume. And so I don't know how we just throw in the ER record. And we think it's prejudicial because it just presents another potential cause to the jury that everybody knows is wrong. And everyone knows that room painting would be a cause. So that's our reason, our motion in a nutshell.
All right. What do I do with that one? Ma'am,
Yes, Your Honor.
welcome back.
Thank you. Good to be back, really. I agree with Mr. Kemp. We're not intending to argue that the room painting was the cause of Mr. Belsky's liver injury. I think there could be a question as to whether it caused certain symptoms like confusion or dizziness, but I think I didn't understand the motion to be to exclude the medical record. I don't think that there is any reason to exclude a single medical record that is relevant to the case. I mean, it's the very medical record where they diagnose him as having a liver problem. So, and it appears over and over again in his medical records, this fact that he was painting during the time. And so I don't know if the suggestion is we redact all of those, which I don't think is appropriate, because I think that there is room to believe that there was a constellation of symptoms. He certainly had acute liver failure, but he also had some neurologic symptoms that could be attributed to the paint, and which, incidentally, when he was in the hospital the first time, he was in the ER for just a few hours. And the symptoms of dizziness and nausea and confusion, once he was away from the room he was painting, they went away, even though he undoubtedly still had elevated liver enzymes. So that is why I think that it is relevant to explain his entire medical condition.
All right. So my next question is this: who's going to tie that up?
Who's going to tie what up?
The other medical conditions and how they're relevant if everyone agrees that there's no expert to come in and opine on some sort of causation or impact of the painting, because it's probably Valspar. Was it a latex type?
Latex, Your Honor.
Yeah.
Well, there's no expert who's going to opine that it was the cause of a liver injury, but our experts would be allowed to, or we would be allowed to cross-examine their experts about whether the painting could be the cause of certain of his symptoms exclusive of liver injury. And that's all we're saying.
All right.
Just how's that relevant? I mean, here you
Well, when I hear that, I think of
Rodriguez.
well, I actually think of Giglio,
Okay.
because in Giglio, and this is what happened there. The plaintiff had significant complaints about 4 or 5 years earlier of low back pain before they had to slip and fall.
Oh, right.
And so the question came down to, and they had some other symptomology, and the question came down to, and in the case at hand, they suffered a disc injury at L4-5, resulting in surgery. And so the issue was whether the pre-existing back condition came in. And I remember we had a rigorous discussion on that issue. And after some discussion, it was determined that the prior lower back injury, although at the same level, was a facet injury and not a disc injury. That's what happened. And there were still complaints of some low back pain, but I kept it out for 2 reasons. Number one, it was a different body part, but number two, it was a different injury. And I think at the end of the day, you have to have something to tie it up, from a causation perspective. Because not everything comes in. You need medical testimony on those issues.
So if I may, Your Honor, I think the question then becomes to us, do all of his constellation of symptoms come in, just not all of the factors that could have caused them? Is that, I'm just trying to understand.
Well, I think the major injury he has would have been liver, right? Liver injury. And if Valspar doesn't cause liver injury, and there's no evidence to support that, then why would anything else come in? Because one thing you don't want to do is you don't want to mislead the jury, right? And you don't want them to... No, you're doing good, ma'am. I'm listening. But
She opens the door by saying, I'm super confused.
So Mr. Neale, as usual, is thinking ahead of me. But if Mr. Belsky's on the stand, and again, Your Honor, I'm just trying to understand. Mr. Belsky's on the stand and says, well, what were your symptoms, Mr. Belsky? Well, I had jaundice. I was nauseous. I was dizzy. I was confused. Are we not allowed to ask him about potential sources of the confusion and dizziness?
well, if you have no alternative causation, it's not relevant. I mean, and here's my point. Do we have a doctor in this case that's opined that, you know what, painting with Valspar would cause dizziness, nausea, and those types of things?
That's
Because all we have, it seems like to me, what we have here would be circumstantial evidence at most, but you need more than that from a medical causation perspective.
You're completely correct. I don't want to interrupt Ms. Anderson. Maybe she's not finished yet, but certainly part of this has already been addressed in some of the prior motions. But I'll allow Ms. Anderson to finish.
Because, man, I don't mind telling you what you're allowed to do and not do, but at the end of the day, it's not what I want. It's for example, if say it was hypothetically 50 years ago, and you had it's probably had to go back more than 50 years ago, but say paint had some potential, that's where I'm going, side effects and those types of things. Maybe turpentine, maybe, things that were in paints 50, 60, 70 years ago. And Mr. Cavanaugh, you know what I'm talking about, because paint isn't always like it used to be. There's a time when it was lead-based and oil-based and not water-based, and turpentine and all those things that potentially could cause some sort of,
Yeah.
inhalation problems make you dizzy.
Yeah.
Heck, didn't kids used to snuff paint for one time or another?
Huffing.
Huffing painting, something like that?
Yeah, then it caused medical problems beyond just their intoxication.
Exactly.
Which is what happens today a lot.
Yeah.
I'm not touching that part.
I'm just looking at it from a medical perspective, right? And we don't have any,
Absolutely, Your Honor.
when we don't have any medical testimony that the symptomology regarding, although circumstantial, the symptomology that he reported when he went to the ER was related to the paint.
That's it, Your Honor. And Ms. Anderson,
No, I'll see.
Yeah. I mean, that's really where it comes
That's
down
it.
to.
You're right. I was thinking of the FCH1 LLC Rodriguez case, Your Honor,
Yeah.
which dealt specifically with medical records. And, Your Honor, we made concessions early on in one of our motions for summary judgment because Mr. Neale pointed out there were certain bills for Belsky and Haley that did not appear to be related. And those were taken out and we reduced our amount. And it's no different here in terms of what Ms. Anderson's trying to advance, the position she's trying to advance. There are no doctors who can link the paint to any problems to a reasonable degree of medical probability in the form of the medical report, and they have not retained an expert who does so. So you hit the nail on the head right up front, John. If there was a doctor who could do so, then fine, that doctor should have been identified properly under 16.2b, and there should be a causation opinion issued and everything else that goes along with that type of disclosure. But it's not there. And I had the privilege of reviewing Dr. Dollar's report and her deposition over the weekend, along with some of the other doctors retained by UNFW, and they don't have a doctor that does this. So there is no way of putting it together. And, I think your recitation of the case law on this point supports granting our motion and denying the request of Ms. Anderson.
Well, I mean, ultimately, and I do understand he was painting, but there has to be a medical doctor, a DO, or someone such as that to tie it up and say that, you know what, these are the types of symptoms you can sustain as a result of using whatever Valspar, whatever number latex paint it was, and we don't have that. All we have is this circumstantial evidence he was painting, but at the same time, he apparently had some sort of acute liver problem when he went to the ER. So I'm going to grant the motion, and the reason for it is really that the simple, we just don't have anything to tie it up. And I think this is important to point out. So, yes, sir.
I'm sorry, I don't mean to interrupt, Your Honor, but I do think that Dr. Dara does connect the symptoms to the paint, in her opinion.
What does she say?
She says the toxic fume exposure from the paint that brought him to the hospital could explain some of his symptoms in the emergency department, particularly since he improved on oxygen via nasal cannula. VOC exposure as an environmental toxicant has been associated with steatohepatitis and liver cancer. Solvents and chemicals in paints are known to cause liver injury via oxidative stress and injury to mitochondria. She then goes on to say that she believes most of those cases are occupational exposure and that his short-term exposure was not likely to cause his liver injury. But nonetheless, she did say that it could explain some of the symptoms that were less consistent with liver injury.
Your Honor, I think what she said at the end is exactly what I read over the weekend. And again, it's not a reasonable degree of medical probability.
But okay, but here's my next question. And she says what she said, and assuming, and I'll give the defense as far as this discussion is concerned, the benefit of the doubt. Okay, she said what she said, but it didn't cause a liver injury. If they don't make complaints regarding certain symptoms at the time of his examination, how does that open the door up?
Well, that's what I was asking, whether if the door is open and he says, well, I had all these symptoms and that took me to the hospital, whether are we precluded from asking him about the painting?
Okay. And what were the symptoms again?
The specific symptoms she was talking about were the confusion and dizziness that dissipated once he was in the ER on oxygen for a couple of hours.
All right, okay, I understand. Are you making a claim for the dizziness?
No, Your Honor. Like I said, this has been addressed already in the motion for summary judgment on the bills and the records. I don't know why this is coming back up. I don't know if Ms. Anderson was here that day.
I was here that day, and actually the 5/24/2018 bill is still on the list.
Well, Your Honor, I think the problem is that these symptoms are associated with liver injuries. And so they just want to come in and say, well, you have these symptoms that are associated with liver injuries, and we're not saying the painting is the cause of the liver injury, but the painting could be the cause of these symptoms.
Here's my next question from the foundation. It's just funny how these take more time than every time. Here's my next question. I mean, for the paint, it's been a long time since we handled these types of cases, but is there a material safety data sheet for the paint?
There is, Your Honor.
And what does it say in that?
So you better wear a ventilator if you're going to use this stuff.
Is that?
You know, Ari, give us a second to pull this one up for you, for the benefit of the court.
What does the material safety data sheet say as far as symptoms are concerned?
Let me try to pull it up, Your Honor. Maybe Mr. Stevens can put it up on the screen for us. Yes, thank you.
Yeah, let's go down to section 2.
Dance organs.
Is there another page?
Yes, sir.
Was any inquiry with this plaintiff as to the facts and circumstances regarding this painting?
Yes, sir. Extensive. It's a windowless room. He painted 3 walls. He had been at it for 3 days. He related his symptoms to the paint. He relayed that to the doctor. That's why it's in the medical records. They called poison control. As Ms. Anderson said, he improved rapidly and was discharged within a few hours. He returned the next day with the liver injury. But that's why this visit and these symptoms, Your Honor, are both in the mind of Mr. Belsky. circumstantially by fact and in the mind of both plaintiff's physician related to the pain. That's why Dr. Dara opined as she did. We're not trying to attribute the liver injury to this, but we ought to be able to explain the symptoms on May 24th.
Your Honor, I could have sworn this is one, and Ms. Anderson, correct me if I'm wrong, I'm inviting you to. I thought this was one of the ones that Mr. Neale objected to, and we removed that cost and that treatment from our MSJ. I thought this was, I think that was the one.
I think you may be thinking of the Haley.
Well, it's two. We reduced both of them. We
Right,
reduced,
and-
we reduced Haley and Belsky.
And Belsky's was the post-injury, the
Nutritionist.
very
So, Your Honor,
urology and
if
things
May
like that.
18th is the issue that they're concerned about,
May 24th.
May 24th, this one day, the day that preceded him coming back for a liver injury, I don't think that's an issue that we have to worry about. Because we won't open that door.
They won't open the door up, that's what they say.
We'll see, I guess.
Okay,
Thank you, Your Honor.
all right. Okay. We'll see if they open the door up, but for now, but even based upon the defense expert, as it pertains to the symptomology on what day again was that?
May 24th,
May
2018.
Yeah, that visit. So I guess granted in part, denied in part. They open the door up. So is it time to go now?
We figure out what we're gonna do tomorrow?
I don't know.
10:30?
Well, here's the issue, and this has been I'm gonna have to talk, hopefully Lynn is still here. We have so much to do, and we're gonna be bringing 65 panel members, 66 panel members in here a week from tomorrow, right?
Oh, okay.
Pardon? No. I mean, the only reason I'm saying that, we have things to think about. Right. I don't have an answer right now. I don't mind telling you that I don't, but we're getting very close. And I realize this matter will not resolve itself. It's probably somewhere down the road with insurance coverage issues and the like that are currently pending, right? Yeah, so. And then I'm not a concern because we will. What did we put on the jury questionnaire as far as time for trial?
6 weeks, Your Honor.
6 hours. 6 weeks. Can we do it in 6 weeks?
No.
What do you say, 6 to 8?
I think we've already lost a week because we got a little bit. That's just my opinion.
Well, realistically, I guess you know what? How many jurors are left before I make decisions regarding who should be removed for hardships? Any idea? 500, 600, 700, 200? I mean, I don't know.
I don't have the number in front of me exactly, but my recollection from last time I had it up was I think the ones that are undisputed that are coming in after all the agreed upon excusals is more than 300. I might be including the disputed ones if they're brought in, but we're, I think 300 to 400 is where we're at without considering the last batch.
And with the 300 or so, I haven't looked at them, I'm gonna have to go through them, but was there any issues regarding time qualification?
Anyone who had issues with time qualification or hardships that were undisputed, we've agreed to excuse and have been excused. So of the people coming in, they are time qualified, with the exception of maybe a handful of the disputes, which the question is, you know, are they sure of the hardship? If recommendation in terms of the best use of the court's time. I don't know that going through the jurors that we disagree on is really going to make that much of a difference, because a lot of them, they check the box that they're able to serve. And so I don't know that determining whether people who check the box as able to serve should be excused for a hardship that they're not really advancing is really worthwhile. There are probably some that check the box that we do not agree on for one reason or the other, usually because there was a question of whether their stated hardship was really a viable hardship. It seems to us that the best thing to do is bring those people in, and if be able to, ask them questions to validate the hardship, and if they're a legitimate hardship, then of course we would agree to excuse them. It's just a question of it's not clear that they have a valid hardship, and there's not a huge number of those people. So
When you say there's not a huge number, how many are we talking about?
There's enough to make a difference. We would have to get the number for you, Your Honor. We'll get it in the morning, but there are people that clearly will not be able to serve on this jury who didn't check the box, and that's why there's a disagreement.
Yeah. Well, that's why, because what I don't want to do, I don't want to waste precious time in bringing them in if it's patently apparent that they can't serve for whatever reason, even though they didn't check the box. I mean, that's important, no question about it, checking the box, but also the responses are important too. So I'm going to have to just look at it on a panel member by panel member basis.
Yeah, unfortunately, if that's the way we have to go. Still might be more efficient to do that before they arrive here, though.
Well, absolutely, that's my point. I think it saves time, but we'll find out. I'll see where Lynn is tomorrow. All right.
Thank you.
What time tomorrow? 10:30. 10:30. Enjoy your evening.
Thank you.